Hello, everyone. You're welcome to today's live session. Please join in. We're about to talk about some new rules affecting immigrants in the United States. So please join in. Let me make sure that you guys can see us on Instagram. And if you can see me and hear me, great. Please type USA or drop an emoji of the US flag. And that will be a signal to get started. We have a number of very interesting things to talk about. So please join in, so that we can get started. Okay. Today, let me see if I can just immediately start sharing my screen while we continue to wait for people. We've been able to resolve the screen sharing. I'm not sure what happened, but today we're sharing our screen on Facebook, YouTube, LinkedIn, and Instagram. All right, guys, can you type in USA, USA, or you can drop an emoji of the US flag, please, so that I can see that everyone can hear me well. If you can hear me, please do that very quickly. All right. Today, the Department of Justice, which is responsible for overseeing the immigration courts around the United States, they posted a Federal Register notice, or they made a publication in the Federal Register concerning a final rule, meaning this is not a proposal, this is a final rule that is going to go into effect within the next 30 days. And this final rule impacts the right, the ability of immigrants to file appeals once their cases are denied in immigration court. I'm sorry, I'm using the publication that they made yesterday. So it's the same thing. They released the notice yesterday and then today they published it. So we're using yesterday's notice that they released. It's pretty much the same thing. Okay. Now, this document is called an interim final rule and it's amending regulations on how appeals can be reviewed by a body called the Board of Immigration Appeals. All right, let's jump into the substance of the matter. Okay. Now, okay, I didn't highlight this part, but it's still very relevant. So we are going to start with it. The rule says that, well, let's go to the reasoning behind the rule. The notice is talking about the fact that the Attorney General, through regulation, provides the Board of Immigration Appeals. The Board of Immigration Appeals is the board that will review your decision after an immigration judge denies your case. If your case is approved, then there's no need for a Board of Immigration Appeal to review it, unless, of course, the government appeals the grant of your case. So if you file a green card application or you apply for a green card in immigration court, and as an immigrant, your case gets denied, you have another opportunity to file an appeal, usually within 30 days of the judge's decision. If your green card is granted and the government or the on the other side thinks that the judge was not correct in granting you the green card, the government can also file an appeal. And that body that reviews the appeal is called the Board of Immigration Appeal. Okay. So the Board of Immigration Appeal has multiple adjudicatory options. And one of them is something called a summary dismissal, where they dismiss a case very quickly. They don't go into the merits of the case. Second is called something called an affirmance without opinion. That's where they say that, oh, the judge was correct. We're not going to draft a 10-page opinion as to why the judge was correct, but we agree with the judge's outcome. Or the Board of Immigration Appeal, they can also do a decision by a single appellate immigration judge. One person on the BIA can give a decision. or a panel of 3 appellate immigration judges, or bank means all of them are on the bench and then they'll give a decision on your case. And so this interim final rule that is amending how immigration applications can be reviewed in the or by the BIA is particularly amending how the summary dismissal procedures can be used by the BIA. And the bottom line is that there are lengthy appeal backlogs. In this 42-page document, the Department of Justice says that there's currently over 200,000 appeals pending by the BIA. And when they look at the situation with more appeals being filed by the day, because obviously the US government's posture is to deny, they're denying more and more cases. And more people are also filing appeals. And so when they look at it, it's like, okay, there's a bunch of appeal cases pending and there's more coming in. And so the tactic is that, okay, then we're going to be dismissing people's appeals, pretty much not allowing them to go through the appeal process properly. And they said they are amending the summary dismissal procedures so that they can better regulate the backlogs. Okay, now let me go here. Please don't forget to drop your questions. We will be answering your questions in the order in which they, in the order of, how I see it. Okay, if I see your question, then we can address it once we get started. Okay. Now let's start with the main key points, and then we'll go to the relevant page of the Federal Register to see what it says. BIA merit review has now become discretionary. The default is a summary dismissal. What this means, let's go to page 12 of the document, page 12. Okay, I highlighted it here. So you see what the Department of Justice is saying. It's saying that the board of, okay, let's look at some numbers first of all before we go to the first main point. It says that let's go here. Between fiscal year 2015 and the end of fiscal year 2025, that's a 10-year period, the board's pending caseload has increased more than fivefold. So as of 2015, there were about 37,285 pending appeals. Now the cases have jumped up to over 200,000 pending appeals. And then they're like, the board is at a point where it's just not able to keep up with incoming filings while tackling the backlog. So it's like they have to look ahead because they have to, there are more cases coming in, and there are also backlogs that they have to work on. They are not able to, and they say the board cannot and does not need to adjudicate every case on the merits with the tools at its disposal, including the ability for single board members to issue an affirmance without opinion. So what they're saying is that in order for the board to quickly review the cases pending, or they want to be more flexible with the board's reviewing of cases. So the default or the automatic thing that they will do once they get your appeal is to dismiss it. Automatically, your appeal is already dismissed once it gets there, unless a majority of the current board members, unless a majority of the current board members vote to consider the appeal on the merit. I believe there are currently about 28 board members. They keep changing all of this so much. Let me see. I think there were 28 the last time I checked. I don't know if they were reduced to how many board members of the BIA. Let's see, as of 2026, how many we have. And so the majority will be more than half. Yeah, okay, 28 board members. Okay, that's still correct. 28 board members. And so if we have 15 board members saying that, okay, yeah, we want to consider your appeal on the merits, then they are going to dismiss your appeal. Now, if they decide that they're going to dismiss your appeal within 15 days of your filing, your case will be dismissed. And now, many immigration appeal, the filing fee for the immigration appeals is $1,030. That's a lot of money. This jumped up last year. It was about $110. If you're filing an appeal with the BIA, you've been denied, your asylum has been denied with or at the immigration court, and you are filing an appeal to the Board of Immigration Appeal to say that, can you review what the judge did? I don't agree, or the judge was wrong. As of last year, before the Big Beautiful Bill Act was implemented, the government filing fee was $110. Now it's $1,030. It went up to $1,010, and then recently this year went up to $1,030 for the government filing fee. So as soon as they get it, default is to deny it, unless at least 15 members of the BIA panel decide that they want to review your case on the merits. Okay. Yeah. And so what they're saying is that once they deny your case on the merits, then you have the opportunity to do a petition for review at a federal court. Okay, so that's their solution. This looks like they're just putting a band-aid on a huge surgical wound, because they are saving themselves at the BIA and then just passing on the work to the federal courts, because already the federal courts are seeing an overwhelm in the system because of immigration detention. Judges and immigration judges are saying they don't have jurisdiction, they're denying bonds, sometimes say they don't have jurisdiction. And then the case goes to the federal district courts, people are filing habeas corpuses, and so they are also getting inundated. Now they want to add, these cases that are denied to the federal district courts so that they can review them. Okay. And so the automatic recourse is to deny your appeal unless there's a majority of the BIA board members who say they want to review your case on its merits. Okay. Now, please note that this new rule will only apply on, I believe, March 8th, 2026. Decisions issued after the rule's effective date. The rule goes into effect 30 days after today. Since its publication, I believe it falls on March 8th. The Department of Justice has also said that there is, they claim aliens do not have a statutory right to merit review by the BIA. Okay, so let's move on. Now, as we mentioned, the appeals are going to become very fast and very routine. That's going to be the bulk of cases. And so the implication is that you pretty much have one fair shot at the immigration court. And so if you mess it up, then it's likely going to be hard to get back on track. So it's very important to make sure that your deportation defense is airtight and you understand how to go in with a predetermined strategy. Okay, that it becomes more important that at the level of the immigration judge, where you're going to the immigration court, to make sure that you filed your case properly and you are defending it properly. There's a very interesting, let me give you guys this interesting stats. The Department of Justice gave us these numbers. I wanted to find it on the screen. It said that between October, let me pull it up, between October 2023 to September 2025, out of, I'm looking for it, over 55,000 cases, only 123 cases were sustained or approved. Only 123 appeal cases were approved or sustained by the BIA. That's 0.2% of cases that go through the BIA. Actually, those are the only cases that come out victorious. I found it. It's at the footnote of, I believe, footnote number 8 on page 12 of the document. Look at that. 55,065 case appeals. Only 123 out of those cases, the BIA sustained the appeal or approved it. The BIA said that, oh, I actually agree with, these immigrants. I actually agree with these immigrants, and pretty much largely, they're saying that the immigration judges are generally very correct, and the margin of error is very, very minimal. And so they think, I guess they are using this to justify why not every case has to be adjudicated, because what they are kind of saying is that, well, in any event, majority of the cases that go to the BIA are denied. Okay, now the next main point is that the general appeal deadline to the BIA has been cut from 30 days to 10 days. General appeal deadline has been cut from 30 to 10 days. This is another, okay, I have it right here. So the interim final rule will also change the deadline for filing an appeal with the board from 30 to 10 days, except for cases involving certain asylum applications. Okay. Now, which asylum cases still get 30 days? 30-day deadline remains when asylum is denied on grounds other than the ACA, the Asylum Cooperative Agreement, 1 year filing deadline or 1 year filing bar, and then there's a prior asylum denial. So if you look at it, these reasons are procedural reasons. And if your case is denied based on procedural reasons, then you are going to still get the 10-year time frame. And it's a very short time frame, because by the time you are done with the hearing, I mean, even days leading up to the hearing, months leading up to the hearing, it's extremely stressful, extremely exhausting. And the hearing sometimes can last several hours, sometimes 6 hours, sometimes 4 hours. And so if you just have 10 days after the hearing, it's quite unfair, because sometimes, look, some of the hearings, the outcome may not be as was expected. And so this can put some people into a state of shock. And to give them no time to recover, say, look, you just have 10 days. And sometimes the records or the files are 1,200 pages, 4,000 pages, 600 pages. And the attorney has to now review all these things, review the judge's decision. The judge's decision can be 10 pages, 15 pages. And sometimes you may not receive the judge's decision even on time to say you're going to file an appeal. Not even, the timeline is extremely short. But the interim final rule is saying that if your asylum case, the reason for your denial is largely procedural, then you have a 10-year bar. Otherwise, if your asylum case is denied because of the merit of your case, like they go into the case and there was an issue with something in their case itself, not a procedural thing, then you can get a 30-day deadline. The next change is that there's now going to be something called simultaneous briefing, not a staggered briefing. So usually the BIA would, once you file your appeal to the BIA, then there could be a reply by the government, a deadline, then a reply by the government, and you could also reply. Now there are no reply briefs. Everybody's going to be, both parties, the government side and the respondent or the immigrants, they will file their cases at the same time simultaneously. And they will only allow extensions for exceptional circumstances, if you want an extension of how, when you want them to give you more time to submit a reply or your brief, then it's not going to happen unless you have exceptional circumstances. They describe exceptional circumstances. I highlighted it, but I can't find it now. But it was more like if there's a death of a spouse, if there's a serious illness, those kinds of things, a death of a family member, not a death of like a grand auntie's cousin, but like a death of a mom or a child or a sibling, those kinds of deaths very close to you. The next thing, main point number 6, is that immigration judges no longer review transcripts. Immigration judges would review transcripts first, usually when they're done with the case, before they forward it to the BIA. The DOJ is saying that now they rely on digital audio recording and existing transcript correction procedures. And so that IJ, the immigration judge reviewing his own transcript, is just unnecessary delay, and it distracts them from adjudication. Let's go here. Okay, yeah, this is the exceptional circumstances on page 22. There'll be extensions authorized in the case of battery or cruelty to the immigrant or a child or a parent, or serious illness of the immigrant, serious illness or death of the spouse, child, parent of the immigrant. But this doesn't include less compelling circumstances, so it has to be very serious. Okay. Yeah. All right. And then let's go on to number 7. There are limits now on BIA leadership delaying cases. We'll skip that one. Then number 8 is terminology changes. I was very surprised that this had to make the cut here. We're going to page 25, where they now have, they're trying to change, because the changes will be in effect from May 8th. Now, they are not going to refer to non-citizens as non-citizens or refer to them as aliens. Okay, it's right here. On page 25, it says they are making changes to change the term. So they are making the changes to the Code of Federal Regulations to change the term non-citizens to alien, and the term unaccompanied child or children to unaccompanied alien. Why does this matter so much to them? It should non-citizen. Why not non-citizen? Why alien? Because they want the derogatory one, the derogatory term. Okay. Now, this rule is a final rule. It did not go through the regular, notice, proposal, and comment period. Under the Administrative Procedure Act, agencies, they must normally give public notice if they're trying to make a rule. If there's a new rule, they'll publish the notice of the proposed rulemaking, and then they'll give an opportunity for comments before they'll finalize a rule. However, there are some statutory exceptions that the DOJ invoked, or the Executive Office of Immigration Review invoked for this appeals rule. They mentioned, let me pull it up here. They mentioned that the changes that they're trying to make is procedural, mechanical, and that those rules of agency procedure or practice, they are exempt from the notice of rulemaking. And then they also gave the foreign affairs exemption again. If you guys remember, we spoke about the foreign affairs exemption when we talked about the diversity visa lottery rule that said everybody had to pay $1 to participate. The foreign affairs exemption, where the regulation involves the foreign affairs function of the U.S., because you see that it affects international immigration control and U.S. relationships with foreign governments, and if it's supporting broader U.S. foreign policy interests and things like that, then if they delay implementation for notice and comments, it could undermine cooperation with foreign partners. So they gave those exemptions as part of the reasons why this did not go through the notice and the comment period. All right. You guys can drop your questions and comments, and we can talk about we'll move on to some other topics, but let's wrap this up. And so this obviously curtails the right of immigrants to appeal their immigration court cases. It's a really serious, I mean, if you, the Federal Register notice says that they are aware that this is a really like a substantial change. It's a really substantial change. It's not a very small minor change. It's quite major, and it's going to affect many people. At the immigration court level, make sure you have proper legal representation so that you give yourself the opportunity to present the best possible case for an approval, to maximize your chances of an approval. Because once the case gets denied, then it becomes difficult, not impossible. It could become difficult to have the appeal sustained. I showed you guys the numbers. 0.2% of cases that go through the BIA, the appeal process, are sustained or approved. I mean, less than half of 0.1%. So you can tell that almost every case, we can say, almost every case that goes on appeal gets denied. Okay, so your best shot is at the immigration court level. That is your best shot. So make sure you take that shot. You gotta stand well, you gotta hold the ball well, you gotta make sure that you got the right training, and once you're shooting that ball, is landing right in the net once and for all. Okay, let's talk about just this other trending news this week. There's a lot. There's always so much happening, and our time is always limited. But we can just share this this funny trending news where a judge. I'm sorry, not a judge. She's a lawyer. I meant a lawyer, prosecutor. She works with the Department of Justice, and she went to court and went and told the judge that her job sucks. Her job sucks. The system sucks, and she's trying to do everything she can to get what the judge needs. And this is after the judge asked her why his orders were being defied, and she said, "Look, Judge, sometimes I wish you would just put me in contempt, Your Honor, so that I can have a full 24 hours of sleep." So I think this woman was brought on. I reviewed some of the court transcripts concerning this case, and she now works on, she's obviously been removed from her post and is now back to Department of Homeland Security. So it sounds like it's a demotion somewhat, but she was saying that she wasn't trained and she just got on, I believe, this January, and she has over 80 cases. Her name is on over 80 habeas corpus cases. She doesn't have training, she doesn't have help, she's working day and night. It's not surprising, because what the government is doing, I mean, we've been wondering because it's just back-to-back policy changes. So somebody's suffering somewhere, and these are real human beings. But yeah, so the judge, the lawyer was removed from her role because I guess they didn't want her spilling more secrets because she was just too candid. with that. Let me see if I can read a couple of questions and we'll call it a day. Mensa Arthur on TikTok says, when are they doing the diversity visa lottery again? Let me check now if there's any update, and then I doubt there's any update. I was thinking about it this morning because the US government knows that they could not, they cannot just cancel the program. They've just paused it. I'll tell you the last guidance on the diversity visa lottery by the Department of State was on December 23rd, 2025. So we haven't had anything else. And that, the time is running. The program is theoretically still a program. But they've used this pause to just derail the program. I'm not sure if there's any lawsuits ongoing to challenge this. There's just so much overwhelm in the system. Yes, there's no announcement about the diversity visa lottery program yet. GMO says, can you marry in Ghana but still file for fiancé visa or K1 visa for your wife in Ghana? No, you cannot. Please, people make this mistake all the time. A marriage in Ghana is valid for immigration purposes. K1 fiancé visa is only for people you are not married to, your fiancé, not somebody you are married to. If you are married to them, it's a spousal visa that you file, not a K1 fiancé. Please don't make this mistake. Some people think that if they just do a traditional marriage, then they are not married because they haven't done the white wedding, and then they'll do the K1 fiancé. You'll wait 4 years, 3 years, until your case arrives at the US embassy, and then your case will just get denied. This breaks up some relationships. I've seen it because sometimes they've waited 4 years just to get the K1 visa so that the person can come, or sometimes even 3 years. Because some people will make some errors along the way and it delays their own process. And sometimes they may not even designate the consulate, so the case may be approved and then it's sitting at the USCIS. You have to file the IA-24 for USCIS to take an action on the approved petition to reroute the petition to the right place. So sometimes some people will go through all of this, and the K1 can take sometimes 4 years, and they get to the embassy only for the case to be denied. The girl was 36 when she started waiting for you in Ghana. By the time she went for her interview, her case is denied. She's 40. She's trying to give birth. She's like, nope, she's not doing this anymore because it's going to take another 4 years for you to resolve the issue. It's not a good situation. So make sure you're doing the right thing. Contact us. You need any help, please. There's so many devastating things that are happening because people don't know what to do, went and gave their cases to people that were not qualified to help them with it. Can I apply N400 with one misdemeanor, disorderly conduct 2020? Well, you have to contact us to look at what those charges were, what the court disposition was, and we look at your positive equities. First of all, we look at whether is that crime even deportable. When you have any crime, we look at was it a deportable crime. Number two, is it a crime that shows that you lack good moral character? And then number three, is it we're looking at, is it a conditional bar to good moral character, or is it a permanent bar to good moral character? Then number four, do you have any positive equities to overcome that? So there's a number of things we have to look at. Please contact us, AK Poku, and we'll help you make sure you don't make any mistake there. All right. Okay. Robbins on YouTube says, my I-130 was approved because of the immigrant visa pause I'm contemplating whether to submit my affidavit of support on the DS-260. What country are you from? Um, generally, you guys may know that the immigrant visa pause is just an issuance pause. It's not a processing pause. So cases continue to be approved. I'm sorry, cases continue to be processed. It's at the stage of approval that they may not be approved, but there are a couple of exceptions. Please contact us and we can discuss more with you. All right, guys, let me see if I have any more questions here. O'Shane McCarthy says, is it okay for me to still go ahead and submit I-130 filing form for spouse? That's what's happening now. What do you mean what's happening now? What exactly is happening that you're talking about? Um, the best time to submit your case is when you are eligible. It doesn't matter what's happening, cases are still getting approved. So please don't get carried away with what you're seeing. The cases are still getting approved. If you're eligible, sure, you should go ahead. But I've told you guys, even if you don't intend to hire an attorney, at the very minimum, make sure you have a consultation to discuss and to review. What should I do? Should I move forward? This is what I have. These are my cards on the table. What is the best move for me? Okay, make sure you do that with an attorney before you move forward. That's what I will tell you. Okay. All right, guys. Well, thank you so much to everyone for joining us. If you have not followed AK Poku Law across social media platforms, make sure you follow us now. And we'll be posting a lot more information on our socials. Follow us and make sure you engage and interact with our posts. I'll see you guys all. Next week, let me tell you guys, next week I may not be coming live. I have an international trip coming up. And so it's likely that we may not be live. Very, very likely. Very, very likely. So yeah, we'll keep you posted. Someone on TikTok says, Fearless Edition, good afternoon. Can someone get married despite what's going on at this point? Your right to get married has not been touched. You have the right to get married. You have the right to get married. So that has not been tampered with. You absolutely have the right to get married. Please contact us so we can discuss what your concerns are, what you're trying to do, and give you legal advice. Okay, guys. Well, thank you so much for joining. As always, you need our help with any U.S. immigration matter. AK Poku Law, we represent all immigrants in all 50 states, whether U.S. citizens. Also, we also represent U.S. citizens because some of them could be filing cases for their family members. We represent clients in all 50 states throughout the US and around the world and in all US immigration matters. Okay. So I will see you guys all next week or in a couple of weeks, depending on what happens. All the best to you guys. Take care. Have a great weekend. Thank you for joining us. Bye.